Bottom line, what you can and cannot do. I put this on page 25. This is the shortest sentence that I can say about this. It is only permissible for not more than 2 guests to stay in a multiple dwelling for less than 30 days under 2 circumstances. If the guest or 2 guests are living within the household of the permanent occupant, i.e. the tenant is home, or if the permanent occupant is temporarily away and the guest doesn't pay. That's what's allowed. But there's more. And this is where we get into the rent stabilized piece. We need to settle that stage for the rent, further prohibitions for rent stabilized tenants. Rent stabilized tenants are not allowed to profiteer. All right, so we have the Ezeki case where the appellate term first said in 2015, the integrity of the rent stabilization scheme is obviously undermined if tenants, who themselves are beneficiaries of regulated rentals, are free to sublease their apartments at market levels and thereby collect profits which are denied the main landlord. And then here's a Kings County case that's often cited in this area, B Park versus Duena, that the tenant had engaged in profiteering by renting out the apartment or allowing his children to rent it out to a series of short-term transient tenants for commercial purposes. The court explained that such brazen and commercial exploitation of the rent stabilization of a rent stabilized apartment significantly undermines the purpose and integrity of the rent stabilization law and code and therefore is incurable. That's why this really gets crazy for the rent stabilized context, because these violations, this profiteering, is incurable. So this is really one of the few species of rent stabilized case where the landlord can go straight to termination with no cure period. That is huge. That is powerful for a landlord, and it's scary for tenants.